Party Devon Reese, members of the council of the City of Reno, State of Nevada. Wait, first let's start, do we have any disclosures on this item?
I have a disclosure, actually.
Let's go with Commission Counsel Bassett first.
Although Senior Deputy Attorney General St. Jules is the acting commission counsel in this matter, I would like to make a disclosure out of an abundance of caution and for transparency. In my private capacity, I am a client of Moffitt, Cox & LaGoy. There's previously been a split of opinion by the commission as to whether a typical attorney-client relationship creates a commitment in a private capacity by a public officer or an employee to a law firm under NRS 281A.065, but I am erring on the side of caution in making this disclosure because I'm aware that Mr. Reese is also a client of Moffitt, Cox & LaGoy, although he is not represented by the law firm in this matter before the commission today. My representation by Moffitt, Cox & LaGoy in my private capacity is unrelated to Mr. Reese or any matters before the commission. I am financially responsible for the payment of Moffitt, Cox & LaGoy's fees at the prevailing rate, and I have no other business relationship with the law firm beyond being an estate planning client. I do not vote on or make any decisions on matters regarding before the commission concerning Mr. Reese. However, my representation by Moffitt, Cox & LaGoy in my private capacity regarding matters unrelated to Mr. Reese or any commission matters would not materially affect the independence of judgment of a reasonable person in my position on matters concerning Mr. Reese.
Thank you. Commissioner Moran?
Yes, thank you, Mr. Chairman. I'm a partner with the law firm of Hutchison and Stephan. Mr. Reese was a partner with the same law firm during the time of the events alleged in this matter, and the position of the law firm during that time as a part of the ethics law violations alleged here. And however, I joined the firm after Mr. Reese had already departed. It's my understanding that Mr. Reese's last period of employment was in February of 2024. I came on board a month or so thereafter. We do not have any overlap with the firm, and I do not have any personal relationship with Mr. Reese, not in his capacity as city councilman for Reno, but also as a colleague and a partner to him with the firm. And also was not involved in any of the events alleged in this matter. Do not have independent knowledge of the events alleged outside of these proceedings before the commission. Given Nevada's public policy in favor of public officers performing their duties and voting on matters, and that a reasonable person in my position's judgment would not be materially affected by these circumstances, I will not be abstaining on this matter. I will be voting. Thank you, Mr. Chairman. I'm taking advice from counsel on this as well.
Thank you, Commissioner Moran. Commissioner Lowry served on the review panel for this matter, and therefore she will not participate in consideration of the matter. Also, Commission Counsel Bassett served as associate counsel in some of the earlier proceedings, and therefore she will not participate in Senior Deputy Attorney General Reno St. Jules will act as Commission Counsel for this particular matter. We have the parties go ahead and, or the council go ahead and identify themselves.
Thank you, Chairman, Chair. Yeah, I'm Jonathan Shipman. I'm here on behalf of Mr. Reese in this matter.
Thank you.
And Ross Armstrong here, representing myself as Executive Director.
And it's my understanding that the parties have discussed some potential demonstrative exhibits and have agreed that both may be admitted.
Correct.
Correct.
With no objection, then we'll go ahead and have those made part of our record. So we're considering today an alleged failure to comply with the terms and conditions of the deferral agreement entered in ethics case number 22-104C. An action to be taken if the commission finds there was such a failure to comply. For presentation purposes, we'll first hear from Mr. Armstrong, and then we'll hear from Mr. Shipman. And my understanding is, again, the parties have agreed that Mr. Armstrong will then have a brief rebuttal. So, Mr. Armstrong, please go ahead.
Thank you, and Mr. Josephine, please. Demonstrative aid. This is, in my mind, a simple and straightforward matter. Within a handful of weeks after Mr. Reese agreed with this commission by way of a deferral agreement to maintain compliance with the ethics law, he engaged in a course of conduct contrary to the ethics law. In the review panel in case 22-104C, the case before us, that review panel determined that facts established credible evidence that just and sufficient cause existed to refer that matter to the commission, but that a deferral agreement was appropriate. Reese agreed in that deferral agreement, and there were 4 different requirements of that deferral agreement: that he complete training, that he produce a conflict of interest check process, that he submit disclosures when items involving his firm came before the commission, and that also he maintain, and I think the most important requirement of all our deferral agreements is that once you're on a deferral agreement, you need to continue to obey the ethics law. So that is the part of the deferral agreement that Mr. Reese failed to comply with. The elements of a violation of this part of the deferral agreement is that it has to be another ethics complaint. We received 2 ethics complaints regarding Mr. Reese. The conduct in that complaint needed to happen after the deferral agreement was entered into. The complaints include behavior both before and after, so because there is conduct after, it constitutes a violation, and that a review panel determined that just and sufficient cause exists to proceed with that new complaint. This protects individuals who enter into a deferral agreement from anybody just filing a complaint and triggering an end of a deferral agreement. It says, look, if there's a new complaint, there should be an investigation that should be presented to a panel along with that person's defense of themselves, their opportunity to respond. If at that point a panel says, this new case has enough evidence to proceed, that's what triggers the violation in this term of the deferral agreement. And that is what occurred in this case. In reading all the materials, there's not really a dispute that a review panel has made that determination that that complaint included conduct after we enter the deferral agreement. A deferral agreement really is sort of a gift from the review panel that says, look, there's evidence here that you may have violated the ethics law enough to send this to the commission. But we think with the right resources and guidance and monitoring, we think it's possible you may be able to comply with the ethics law. The carrot in a deferral agreement is if you comply, at the end the case is dismissed. The stick is if you don't comply, then the case will proceed the way the review panel has determined it should. So what exactly happened in this particular case? If you take a look at the timeline in your materials, we have the second case involves travel. The first case involves disclosure and abstention, and the second case involves travel. Essentially, Councilman Reese using city resources to fund his own private travel interests. If we zoom in on the time period that is after the deferral agreement, the time period that is relevant for you today, you can see that Reese entered the deferral agreement in April 2023. That in May of 2023, he completed ethics training. He emailed that he had completed that ethics training. Shortly after that, there are 2 different trips. The total of the private benefit of those trips, as indicated in the response and in the investigation, is in excess of $1,300. Then it takes a while for there to be discovery of that behavior that violated the ethics law, and in March and April of 2024, complaints were filed. We then conducted our investigation into these new complaints, and in September of 2024, the review panel made its determination that just and sufficient cause existed to proceed. That is 16 months into the deferral agreement. I note that the first trip that violated the ethics law was just 3 months. We have 90 days into the deferral agreement. The second trip was just 5 months into the deferral agreement. When you look at the moment that triggers the what I would argue the cause for the vacating the deferral agreement, we still had a third of the deferral agreement left. We're closer to the end of the deferral agreement now. The parties did try to engage in global resolution. That did not occur. There has to be time for Mr. Reese's counsel to respond to the notice. But that's, like 66% of the way through the deferral agreement is when the review panel said, yes, this conduct that occurred just months into the deferral agreement, that there's just insufficient cause that Mr. Reese's conduct was not in compliance with the ethics law. The response argues that in the interest of justice, the commission should just essentially forgive and not do anything in response to this violation of the deferral agreement, and I can't disagree more. I think of the requirements of the deferral agreement in Mr. Reese's case, the requirements of training, of setting up these checks are designed to be a help to Mr. Reese, to help him figure out the ethics law, so that he can bring his conduct into compliance. Again, the most important one is that, you know, we're providing you this help, we're providing monitoring, you need to comply with the ethics law in all parts of your conduct. Again, the conduct that violated the ethics law is just weeks after he completed the deferral agreement. It's after he took training, which includes content about not using public resources for private gain. The response also, indicates that if the commission proceeds, there's not going to be much of a difference in what occurs, which I think is a lot of speculation, but so that the commission is aware, right? If the deferral agreement, if the commission decides that there's been a violation of the deferral agreement, which appears both sides agree, there's no really contesting that a review panel has made a determination as required that meets the deferral agreement requirement. If you don't do anything in response to that violation and the deferral agreement period ends, then Mr. Reese will have no violation in that previous case. If instead you do what I'm asking and vacate that and refer it for further proceedings before this commission, then you'll have an opportunity at that point to let the facts lead you to whether there's a violation. I think it's clear, obviously, that there are. I wouldn't be here asking you to do this today. And there's lots of speculation about whether the violation will be willful or non-willful. Again, that is simply speculation. I think there are facts, there are mitigating facts in this case that may lead to a non-willful violation. There are others, aggravating facts, I think, that might lead to a willful violation. Either way, a full proceeding where this commission can determine if there's a violation would result in a violation. A violation is very different than no violation at all, which is what they're asking you to proceed with. So I'm asking you to reject the arguments and the response and to declare loudly today that you can't be on a deferral agreement and violate the ethics law and have nothing occur as a result. Thank you.
Questions for Executive Director Armstrong? Let's go ahead and move then to Mr. Shipman.
Demonstrate the eight.
I think we've all got it in front of us.
Okay, great. That's just would like to make a few points here. Number one, full disclosure, I am not representing, the city attorney's office is not representing Mr. Reese on the other two cases that are in front of the commission. So I just want to make that clear on the record that there isn't confusion that we're representing both in all of those efforts. So that's one point. Another point is I really want to call out the difference between the case in front of you today, 22-104C, and the other cases that are pending. The first case, the case that we're talking about today, you have to understand, it was a disclosure and abstention alleged violation, right? NRS 281A 420. And again, the allegation essentially for the public is he voted to approve or a collective bargaining agreement at the city council meeting. There was allegations that violated NRS 281A 420. That is a different type of ethics violation, I would argue, than what the allegations are in 24-036C and in 050C. Both of those involve, again, as the executive director talked about, allegations that Mr. Reese used city funds to pay for personal expenses. Again, one is about disclosure and abstention on the record in a public meeting and voting. The ones that are pending, that you're going to be hearing about at a later date, involve the use of government resources. So first I want to just make the point that just in terms of the type and the nature of the arguments, or the types of the alleged violations, I would argue they're not comparable, and quite frankly, to the executive director's point, yes, Mr. Reese did take ethics training, yes, Mr. Reese did set up a conflicts checking system, yes, Mr. Reese did regularly submit his minutes to the city, to the executive director in cases where H&S clients did appear. But again, none of that type of corrective action, which is, I think, I would differ on the assertion that a deferral agreement is a gift, is not a gift. I would differ on that point. And a deferral agreement is a form of potentially progressive discipline. It's designed and it's put in place, I think, by the legislature to really be a device to say, well, there's something potentially here, and we want to give the party a chance, and we want to correct that conduct. And I would submit that on the 420 violations, we see that, all right? We're not seeing a pattern in practice of violation of NRS 280 and 420. Mr. Reese has in fact complied with all the conditions except for the one paragraph that, again, the executive director characterized as the most important provision. And I would somewhat disagree with that too, because I do understand that that provision does, and my reading of it, it has a deterrent effect, and a deterrent value. And that's, the point of putting that in there is to put the accused on notice that, hey, people are watching, you need to look at your activity, you need to think twice before you do this. This is a way to say, you know, we've got you on the hook. Now, that's what the agreement says, but I think the law says a little bit different, and that gets to the point that, you know, the deferral agreement is still on his record, right? So, and under NRS 281A 775(1)B, that can be used in subsequent proceedings in determining, you know, whether or not violations are willful or not. So to say that A, it's a gift, and B, that it's needed for this other, we need to process this and go to full adjudication of this, because we need this in the other case, which again, I want to point out there that where we are in that case, yes, there is no disagreement over the review panel having that case going forward to the next step. But again, the substance of those allegations have not been proven definitively yet, and this body has not ruled on that. And so, I would submit that in a certain sense, we're putting the cart before the horse. That this, to the extent that this needs to even be you need to come back and look at it, or the commission needs to come back and look at it. I think, quite frankly, that I would submit that you know, the other two cases that are currently pending need to be adjudicated, right? Because that, right now, we're just operating, and the commission is operating on allegations, is would be the point. And again, I think that underscores the point that you don't need to adjudicate what's before you today to even use those allegations. The law allows you to do that currently. So I'm left with what's the point of going and adjudicating this case further? If we get to the end of it, he's completed the ethics training. They've developed and implemented a 281 conflicts checking system. And again, and there's no dispute about this, you know, he's been in contact over time with the ethics executive director on making sure that that pattern of behavior was in fact corrected to the extent that there were problems with it. So I would argue that the deferral agreement is not a gift. It worked. It worked. And for that reason, you don't need to go back and revisit it. And to the extent that you do go back and revisit it, my question is, I mean, what is going to be the outcome? Because I would argue that you're going to have to look at that violation potentially in another form. At the time that it was committed, right? And that was a first-time violation, arguably. And that was, again, the nature of that violation was a disclosure and abstention. Okay, so it's not, you know, of the type and the nature and the kind of that you see in these other two cases. So I appreciate you know, the executive director's comment that, you know, that this is important, and I can understand it being used to say, well, is he an ethical or unethical person? I get that, and if that's the argument in these other two cases, I get that. But I'm saying you don't even need that. You don't even need to fully adjudicate this deferral agreement to do that, because that's already allowed for under the law. And again, I would keep coming back to, the 281A770. So whatever, regardless of whatever comes out of this, be it the panel, be it the commission, the concept is that, and the law requires that we treat comparable situations in a comparable manner and ensure that the disposition of the matter bears a reasonable relationship to the severity of the violation or alleged violation. Again, we're not here to determine if in a broad sense, Mr. Reese is an ethical or unethical person. I mean, at most, what we're looking at is on the date that the conduct occurred, it's 22104C. I mean, what happened, and you know, and what would be the appropriate response to that? And again, I would argue that the appropriate response was a deferral agreement. The conduct was corrected. There's no facts in the evidence showing otherwise with regard to that issue, disclosure and abstention, and therefore, you know, it's time to close the door on that. Which doesn't mean that the commission can't open the door at a later date. And I mean, again, to the executive director's point, we're 18 months, 20 months into this agreement at this point in time. This is like, and the other two items were kind of history too. So anyway, that would be, we'd submit on that, and that resubmits that vacating the deferral agreement and conducting further proceedings in this particular case really doesn't benefit anyone or the commission, and it's not particularly a great use of commission time and resources. So with that, I would yield.
Questions for Mr. Shipman before we move to the rebuttal? I've got a couple.
Yeah, please.
First of all, Executive Director Armstrong says that the training included training on use of government property.
The training was the training that was on the, I would defer to the executive director on that.
Yeah, I can confirm the training that was required by Mr. Reese was to watch, what was our old, about 45-minute long, complete ethics law video, in addition to a special video on understanding commitments in a private capacity.
So, I guess I've asked Mr. Shipman, what's the point of requiring him to take the full training if we're only going to consider whether the violation is a comparable violation?
What was the point of doing the full training? I think, I mean, best practice, I think that's pretty much the best practice. Anytime that you have a deferral agreement, you give the accused another, I mean, all the deferral agreements I've said, say that, hey, you need to take another look at the ethics law. So I think that that's just the practice of this. I'm sorry, the question again was, that's the first.
Well, what's the point if we can only find a violation or only find that the deferral agreement could be vacated if it's comparable? The argument is this is not a comparable violation.
The allegations in the other cases are not comparable to the violation that is currently in front of you, the alleged violation today. Because under the broad umbrella of ethics law, yes, right? But under specific kind of the nature and the type of the alleged violation, one is like how a public official is conducting him or herself in a public forum relative to, somebody potentially has a commitment in a private capacity to, and the procedural requirements that you need to disclose and abstain. The other is, you stole money. I mean, those are like, I mean, and I would argue, I would say that, like, at least in my time as a city attorney, I mean, the whole abstention, disclosure abstention component, I mean, there are, as this commission is recognized, there are issues that are maybe not clear as day at times, right? And that require the help of, counsel to figure out what they have to do and what people have to do under that sort of disclosure and extension requirements of 420. You don't really need a lot of that with maybe some of the other, counsel doesn't have to give you a lot of advice and guidance on, is it ethical to steal, right? I really think there's a much different kind of nature of violations that we're talking about here. And again, none of it has been proven. And I do not begrudge, or I'm not standing here saying the commission doesn't have the right to go and prove it or not. And in fact, on those other ones, I would say, go and prove it. If that's where it gets to. But I would say that until that is done, what you're looking at are allegations in the deferral agreement, because that hasn't been proven out either. But you need to actually do that, because if you've already gotten the behavior corrected on all of accounts, is this provision really more of serving a deterrent value? And now, whether it did or it didn't work, is it a good use of resources to continue on down that track? And I'm just asking that because to me, it just seems like you're gonna get to the same endpoint on the abstention disclosure rule, and what have you got for it? Those are resources that could be used for other cases and whatnot, so.
There's nothing in the deferral agreement that requires the violation to be a disclosure and extension violation.
The other charges were dismissed, so I think at this point, we're just left with extension and disclosure. Sorry.
In terms of any other violations, so your argument is that it has to be a disclosure and extension violation to vacate the deferral agreement?
No, I think the way the deferral, I'm sorry if I'm making sense. I think the way the deferral, I don't think there's a dispute over, there's an allegation that he violated the ethics law, and that triggers this provision. I don't think there's a dispute over that. It's just that, the point being is that there's allegations over here and that have yet to be proven. And even the deferral agreement, we have stipulated facts, but that's about as far as it's been proven at this point, so.
Other questions from commissioners?
I was gonna wait until we get the rebuttal.
Okay.
No, I'm gonna wait for rebuttal.
Okay. Online, no other questions? Let's go ahead with the rebuttal. Mr. Armstrong.
Thank you, Mr. Chair. You hit it, right ahead. There's no requirement in the deferral agreement that it be like hitting the same bingo square twice, right? The language in the deferral agreement says Reese must comply in all material respects with the provisions of the ethics law set forth in NRS Chapter 281A. The ethics law does have some language that says, if someone has a subsequent act and they got a previous letter, but the letter was on a totally different subject, maybe that letter doesn't have so much weight. There's none of that type of language in our deferral agreement, part of the statute, right? So if it was just a previous letter of caution or instruction on a totally different topic, you might be able to discount that. I don't think you can discount it just because it's on a different part of the ethics law. I think, for a period of time, I oversaw our youth parole bureau, and you'd have youth, juveniles who had committed a serious offense and they're out on parole, and then standard requirement is follow all laws, and they get like a speeding ticket, right? We don't send them off to a facility again because they got a speeding ticket. The same thing has happened in compliance cases in this one in our office, where somebody maybe is late on turning in their training evidence, or they're late on a payment. We try to work that out, before bringing it to you as a particular violation. In this case, you have an initial ethics case about disclosure abstention, and then I think you do have what has been characterized, I think appropriately, the allegations in this new case is that Councilman Reese has stolen money from the city of Reno, from the people of the city of Reno, to fund his own private travel. That is a serious a serious case. That is not like I'm bringing before you, he failed to get his acknowledgement in by January 15th, or some other, minor infraction. This next case, I think is a very serious matter, and so I think that should weigh on the appropriateness of, if, as Mr. Shipman says, that part of the deferral agreement is designed to be a deterrent, it clearly didn't work, because within weeks of promising to this commission through signing that agreement he would comply with the law, he didn't. There are two things you have to decide today. One, is there non-compliance with the deferral agreement? There's really not a lot of debate or discussion on there. The requirements in the deferral agreement have been triggered. And the second question is what to do. I'm asking you to vacate it and proceed with additional proceedings in this case. I would also ask you to think about, deferral agreements officially became part of our process about in 2017. They're somewhat of a new animal, so I can't point to what we've done in the past, but think about what message you might send to others if you were to not act in this matter. If you were just to say, you know what, it's okay. We don't really care if you violate parts of a deferral agreement. We're just gonna, close out the case. I think that message to other people who find themselves in a deferral agreement would undermine the goals and aims of this commission. I think you have an opportunity to say, when we provide you the opportunity to be on a deferral agreement, we believe in you, but we also are trusting that you will comply with the law. And if you don't, the stick part of that agreement comes into effect. So I'd ask you to find that the deferral agreement has been violated and vacate the agreement and continue on with further proceedings in this matter.
All right, let's, thank you. Let's start with any commissioner questions for either Mr. Shipman or Mr. Armstrong, and then we can move into questions for our council or each other. Commissioners, Mr. Reynolds?
Yes, Terry Reynolds for the record. I would agree that case 22-104C is not factually connected to the case about misuse of city funds for travel on that. However, this is actually for both of you, but was there in that regard, was there a conflict waiver discussed on the front end of effective bargaining? Was that an issue that was discussed by the city attorney's office prior to or during the negotiations? Was there a conflict waiver presented or discussed by the union's attorneys at the time or by the city attorney's office prior to those discussions? And we're getting ahead of ourselves a little bit here, but I wanted to know if there was, because that to me is a very relevant issue in terms of going forward with that portion of that case.
Let me see how I can answer this. As far as, was there a conflict waiver presented by the client or H&S?
Yes, because they would, having two members working for the same firm, they may want to have a conflict waiver on
That I don't have information on that. I'm not privy to that would be an H&S issue, and I don't have at this point in time specifically.
Mr. Armstrong, was there any investigation, discussion of that issue regarding that case?
Yeah, I would have to double check the deferral agreement, but I do recall from the investigation that there were certain processes put in place at the law firm to seek to comply with attorney ethical requirements. What there was not is like a system in place to ensure compliance with governmental ethics law.
So in that regard, from my perspective, then I think we should defer and review that matter before closing out the deferral agreement.
What I can tell you is in the 104C, the facts that I would seek to prove at a adjudicatory hearing would include that at a closed door meeting, Mr. Reese participated without any disclosure or abstention when they were discussing clients of his law firm, and that in a public meeting, he made incomplete disclosure. I think there'll be lots of fight. There'll be probably arguments about whether that was an intentionally misleading disclosure or just not adequate in an open meeting regarding these claims.
So in a sense, you would say that that matter is still not resolved. That issue is not resolved.
Right, I think if the agreement is, if the deferral agreement is vacated and we proceed at an adjudicatory hearing, we would present those facts and arguments.
Thank you.
Other questions for counsel?
Mr. Shipman, I'm really struggling with your reasoning why you think that the deferral agreement that says any violation of 281A would be cause for vacating the deferral agreement. And you're saying that because it wasn't a disclosure and abstention issue, that it really wasn't a violation of this deferral agreement, but it was still a violation of the ethics law with the misuse of government property. So I'm really having a hard time understanding that logic that we can have a deferral agreement that says you cannot violate the ethics law, and then something happens and you violate something else in the ethics law, but that's not how the deferral agreement is written. I'm really struggling with that.
Yeah, no, that's a fair question. I think where we differ maybe is kind of how we're coming at the issue. And I think I've characterized what those comments say to me is that you decided that he has violated the ethics law on these other two cases. That's the point. That's your departure point. That's not my departure point. My departure point is, yes, it may have gone to a panel, but there's still a full adjudication of that hasn't happened. So in my mind, there's a debate about whether there was a violation in these other two cases that are pending in front of you today, or at a later date. And my point is that if you're using, I characterize that as an allegation of a violation. So there's no dispute over an allegation of a violation that went to a panel. Does that trigger the agreement? Yes, it triggers the agreement. But that's different from the merits. The merits are, we don't know if he's stolen money from the city of Reno. That has yet to be proven out by the executive director. So to say that, if you assume that, then of course, then the reasoning that you're giving me makes total sense. It's like, yeah, these are two bad acts, and it's more of the same. But I'm not, again, I'm not conceding that, because I'm saying there's still arguments, as we talked about, that need to be made in 104C, and there are still arguments that need to be made in 56C. And once that's done, then the analysis that you presented, I think, either bears out or it doesn't. And so I'm just saying that if you don't, and you don't need that, is the point. You really don't need that in the other case. You don't need this case to make your case in the other case, and you don't need the other case to make your case in this case. I mean, they're going to stand on their own. Now, again, it's going to, at the end of the day, the potential remedy or whatever the sanction is, there may be some interplay there, but you already have that under the law, that you can use one result in one case in another case. I'm just saying neither one have been fully adjudicated. Does that make sense?
So if I can follow up on that, the argument here is that Mr. Reese has not been found to have violated the provisions with regard to misuse of public property. And so there's not an actual violation yet that's been found. Just insufficient cause has been found by the review panel, which is what was required by the agreement. What's to stop, and I understand the city attorney's office will not represent Mr. Reese in the upcoming pending cases. What's to stop counsel for Mr. Reese from making the same argument that, well, in 104C, I was never found to have actually violated. There was a deferral agreement, so I wasn't found to have violated that, so you shouldn't give it much weight if you give it any weight at all.
If I understand the question, I mean, I think there's, and we've seen this in another case, and there'll be a motion to use the prior case, and it's deferral agreement, it's written, letters of caution. So it's broader than just the deferral agreement. So I don't think there's a barrier.
Well, I understand they can be used, but I guess I'm suggesting that counsel for Mr. Reese may argue that, well, you never actually found a violation there, there was a deferral agreement, and that's lesser than an actual finding of a violation.
Well, I think that's a fair argument, and that really goes to this body, right? I mean, it's like, what do you want to ascribe to the weight of that? I mean, do you view deferral agreements fundamentally as a form of corrective and progressive discipline? That, is to get a result, better conduct? Do you view it as a gift? Do you view it as a sanction? I mean, that's really, I think, within the purview of the commission to decide how you want to, measure that. And I'm not here to tell you, there'll be arguments, but I'm pitching you today. This is not, I think these are the types of questions the commission has to wrestle with.
Understood.
So if the deferral agreement is there to promote better behavior going forward, more ethical behavior. And Mr. Reese, he did ethics training, he learned about not using government property, but then he took 2 flights, right? After he had done the ethics training, and he has this deferral agreement in effect. So the agreement's not really working because he continued to commit ethics violations. Maybe it wasn't extension and disclosure, but now he committed something else.
Again, I'm not here to, I understand the argument. I think that's maybe putting the cart before the horse in terms of what the facts are. I think you're gonna hear argument, you're gonna hear evidence in the other case. And you're gonna have to get that before maybe you can make that definitive statement today. It would be I'm just submitting that. I get it, but it comes down, if you come into this with the idea that we've already adjudicated the other 2 cases and he stole money, then of course, we're gonna go down the pipe on this other one too, because this is another guy. But if you come in with it with like, look, we haven't done that, and if we're looking at this conduct here and it's not related to that, I think there's a point being that, like, look, it worked. The deferral agreement worked. There is no problems regarding extension or disclosure. And again, I think the other case is going to fall or stand or fall on its own merits. And do you really want to, at the end of the day, do you really want to cloud that case and that adjudication with what's happened to date and what's happening in this case? So, it's a pitch, so.
Executive Director Armstrong, do you have a sense of when the pending cases will come to front of us?
We do not have a scheduling order for the other 2 cases. We had a formal settlement conference just before Christmas, and so the scheduling order would still be pending. The time limit, the 60-day time limit has been waived, so I would imagine sometime in the first half of this year is when we would be ready on those other 2 cases. They are, the more recent cases are factually more complex than this first case in a lot of ways, and so it would kind of depend on to what extent there's stipulated facts in that matter. I think for me, I would note that, we established what crossing the line is in the deferral agreement. And we don't make it, you violated the deferral agreement if a complaint is filed against you, because anybody can file any sort of wild complaint. We don't even make it, somebody has filed a complaint against you and we've accepted jurisdiction because we think there's enough there to take a look, right? The line that you've established is, if there's a complaint filed against you for conduct that occurred after you entered the deferral agreement, and after that is investigated by the commission, and the person gets a chance to provide their full response, and all of that information, the investigation and the response, goes to a panel. And that panel determines there's just and sufficient cause to proceed. That is what triggers the violation of the deferral agreement. So I don't think it would be wise for the commission to move that line to, you have to be found to have violated, like formally violated new cases in order to vacate the deferral agreement. In most cases, it wouldn't happen before the deferral agreement would be over. But I think the way that it is structured, where that line is to say, this is like, you know, an educational, you know, deferral process where you're trying to get compliance from you. If we get to that point where there's just and sufficient cause that you have not been in compliance, then keeping that deferral agreement hanging out there to ensure compliance is not useful to any of the parties.
Any other questions for council or either Mr. Shipman or Mr. Armstrong?
No questions.
Okay, questions for our council, and we can, if needed, go into closed session to do that.
I would like to go into closed session.
Yeah, I don't, we go into closed session to deliberate or just to have legal discussion?
Did you move to do that? Or should you move to go into closed session?
Oh, I'm right, I'll make a motion that we go into closed session to deliberate and ask questions of council.
We have a second from Commissioner Reynolds. Any discussion on that motion? All in favor?
Aye.
Aye. Aye. All right, let's go ahead and close the meeting then, and we'll,
Oh, do they need to sign, Carrie, do they need to sign into a new Zoom link?
Yes,
Could they sign into the one that was for our closed meetings?
yes. Put all the
Or-
public domain here?
Yeah, would that be way through?
Yeah.
Or break it through?
Good, how are you doing?
Pretty good.
Yeah. Waking up another day. Isn't that what life's all about?
Yeah.
Wake up and survive another day. At least you got a chance. Good or bad, we all got a chance. I think I'm gonna file an ethics complaint, though. I got one for you guys. You probably don't want to hear it until you see it, do you?
No. Follow the process.
Exactly, the process is good. When you violate the process, that's when you get ethics complaints.
No. No,
I'll take my other camera out of here too.
did you sign on the, oh, I guess.
Oh, that thing there?
Yeah.
Yeah, I was debating whether I wanted to or not.
Is that everybody?
So are you going back in there?
Oh, after they deliberate.
Oh, good, then you and I can talk. Because we met before, remember?
Yes, I absolutely remember. How are you?
I'm good, so I got an ethics complaint. How would I file it? What's the best, can I just email it to you?
Sure, you can email it to me. I mean, the best thing really is on our website, there's a form you can fill out and that goes directly to us, but
Because I
you can also
filed,
send it.
I filed it on public comment last night at the library board of trustees.
Uh-huh.
I've got a lawsuit for a 1983 claim against the library, Director Jeff Scott, and a non-governmental organization called Our Center. And essentially what the emails prove is that Director Scott authorized comp time for all of the library employees to participate in Pride events. And then the library employees were getting remunerated from Our Center by getting free tickets to the Pride events too. So here we are, taxpayers, paying for this non-governmental organization. What's the word for pecuniary?
Pecuniary, yeah, I know. I know, some of the words are hard to say for me.
So that's essentially what the emails that I have prove happened with the libraries in Washoe County, is public funds were being taken to push their private agendas. And what they did is, NRS, what's it, 379? Anyways, there's a statute that says the library shall forever be free and open to the public, right? Unless the library board of trustees makes reasonable regulations, I believe is fairly close to the black and the white. And so what's happened is this library director has taken over the libraries. He closed the libraries to the public and opened it up to this Our Center group. preventing people from accessing books, preventing people from accessing certain areas of the library, preventing people from doing anything in the library that these other people, part of this group, could do. And I believe that's a violation of, what is it, 240? Or what's your ethics?
Well, the 400 is the main subsections, yeah, the Code of Ethical Standards, yeah.
But
Definitely, you
basically
should,
subverting public funds for his own private pecuniary
right,
interests.
yeah, you should definitely file a complaint and provide all that,
I
and
can
we'll
forward
take a
you,
look.
I can forward you the email, 35 pages that I sent the public.
Well,
comment.
so you have to-
It lays it all out.
You have to like, you should attach that, but you have to like fill out the actual form, it's just
I'll do
per
that.
our statute, we have to have the actual complaint, so, yeah. But you can forward the complaint to us, or you can do it on the online
Okay.
portal, yeah.
Based on your knowledge, without seeing anything, is what I described meet the general history of the cases that are found to have violated ethics issues?
I mean, I can't make
I'm
a,
putting you in a box.
I know, but I can't make a legal determination, but we will definitely
Without
look at
seeing
your
it.
complaint.
Okay,
And
I'll
go
send it
from
over to
there.
you.
Yeah.
Okay.
Yeah.
And I've probably got a lot more than 35 pages. I've got probably.
Send them all.
I've got, no, I've
It's
got,
good.
I've got thousands of emails,
Mhm.
and I'm trying to pick the best.
Oh, understood, yeah, no, but
You
definitely
probably don't
send
wanna
that stuff
call-
and we'll look at all
You
of
probably
it.
don't want to read the thousands of emails, you probably rather have somebody
Well,
else
it
do
might
that
take
for
a
you.
long time.
I'm a week into it.
Oh, I bet, yeah. Did you obtain those through like public records requests or, yeah,
Yeah. No,
yeah,
well, and like I said, I'm in litigation currently, and so anything that I obtain in litigation, I'm gonna leave that in litigation
yeah,
until the litigation is done. Anything with some public records, though, I feel like I can use that to.
yeah,
I just want to make sure I'm respecting the court and the judge, and he doesn't go,
Yeah,
you're using the
understood.
stuff that you've gotten discovered to do this other stuff before this is done.
no, completely understand, yeah.
And I'm not a lawyer, I'm just thinking that probably wouldn't be the smartest thing to do.
That sounds like you're thinking that through, yeah,
Try to give the judge the respect because of the power that he's,
yeah,
got to discover stuff.
yeah,
Anyways,
understood.
that's what I've got for you. I appreciate you talking to me.
Oh, yeah, absolutely, nice to see you again.
Absolutely.
Thanks for coming and participating, we appreciate it.
All I'm about is corrupt government. That's why I ran for office, is because government's corrupt, and I'm trying to.
We're happy to have people here, seeing our process, so.
I mean, I adore Larry. He was.
Yeah.
I would.
No, it's, yeah.
And in fact, there was one,
Here's the restroom.
my daughter's first ballet teacher, a woman named Catherine Cameron, had a baby. And her case, I think you were part of that one.
Was kind of somebody listening to your conversation, so you're trying to basically do an ethics complaint because they're misusing funds
Yeah.
for the drag, I'm gonna say the drag queen story hour or whatever.
Right, well,
Yeah,
here's, I don't know if you followed that story that I published it on, but basically, I don't care who anybody sleeps with.
yeah,
I'm a libertarian at heart, in my point of view.
yeah,
Go do whatever the fuck you want.
yeah, yeah,
But when it comes to my government, my tax dollars and all of that stuff, I kind of get bothered when you do things that benefit certain groups
Mhm.
and exclude other groups, regardless of the group.
yeah,
And that's what I found in the library.
yeah.
So I first started going to the library,
It's kind of like preferential treatment, that's basically, yeah.
green, pink, orange, black, white, Asian, whatever you are, tall, short, I'm tall.
Yeah,
I was told that people don't like to talk to me because I'm intimidating because I'm big.
because of what?
I'm big.
Oh, okay.
That was Bethany Drysdale.
Oh, okay,
And I accused her of heightism,
yeah, yeah,
if you know Bethany.
yeah, yeah,
But what I found at the library in their documents is, other than having people assaulted at the Drag Queen Story Hour events by the Rainbow Brigade, that's what they call themselves in their internal emails, they're the Rainbow Brigade.
that's kind of creepy, but,
They organized with our center for, did you ever go to the Drag Queen Story Hour stuff?
no, I went to, I've only gone to one of the meetings,
Oh, okay.
and, I was asked by, I don't think she's the chair now, I forget what her name is.
Gianna.
Yeah,
Jax.
she
Gianna
asked
Jax.
if I could come to, like, just look over some of the material and provide public comment or whatever, but I went to one of the meetings and I provided public
Yeah, I think I
comment.
remember.
Yeah, because it was basically, it was a contradiction, and so that's why I brought it up, and I guess she seized on it to basically lambast the library director, but there was another one she wanted me to come to. I couldn't because I'm in college, or I'm going to UNR, and so I was just way too busy. But anyways, I try to keep up with the stuff. I just only have so much time to do
There's
it.
so much of it.
Yeah,
It's overwhelming.
yeah.
Like
But anyways,
with Reno City Council, I mean, I'd like to go, I just don't have time to go.
yeah.
Because there's so much corruption there.
Yeah, and it's a bunch of different stuff that's going on.
Yeah.
So
Reno City Council, I know is, well, Devon Reese is an example here. And we all know what the county is like. And then you go to the library, and just the other day I was at the school board, you know Paul White?
yeah,
So Paul and I were in the lobby talking.
yeah,
I was recording with a little camera.
yeah.
And the cops come up to us and say, you have to go outside to do this. And I said, you can't have a discussion in a public library, there's.
Yeah, it's a public location.
And I'm going, are you gonna threaten me with a, you know, I push the button, are you gonna threaten me with arrest unless I do what you tell me?
Yeah,
Yeah, I'm gonna trespass you, and then if you don't leave, then I'm gonna arrest you after that. Well, then I'm gonna go outside. Well, you just violated my constitutional rights, who told you to do this?
yeah,
Well, the school attorney told the cops to come and kick me out because they didn't want us to talk.
yeah,
So I sent him a letter the other day that said, pay me $5,000, or I'm gonna take you to federal court. And train all your officers what the First Amendment's about.
Yeah.
Because your officers, and you, as an attorney, you don't get to tell me where I can and can't talk in a public space.
yeah,
It's like you and I are talking right here, and they tell us to get they have a cop come in here and kick us outside because you and I can't talk in a public lobby.
yeah,
That to me is wrong. To me, my issue that I see is whether, again, whoever you are, whatever you are in life, no employee that's paid with tax dollars gets to tell you what to say or me what to say. And if you and I don't like what the other one's saying, we can walk away from each other. We don't need the government to get involved.
Well, with this thing with Devon Reese, though, to me, what doesn't make sense is, so he's a lawyer. I didn't know that, but I was trying to find all the information about the ethics complaints that have been made, but I couldn't find it. All I could find was the deferment thing. That's the only thing I could find. There was no attachments to it or anything. So I was gonna provide public comment, but since I didn't have any of the facts or evidence, I'm not gonna go based on what a news agency says or something like that, because that's not appropriate. But the thing is I'm originally, I have a military background in financial management, and the thing is misuse of government funds is super serious, and I'm also a graduate of TMCC's paralegal program. I plan on becoming a lawyer myself, so I know ethics is super important. And the thing is there's not much difference if you're misusing government funds. That's not going to be any different than misusing clients' funds. So the thing is he didn't have training on, he had training on with the law, you know, the legal side, but he didn't have training with, you know, about government ethics. To me, that's irrelevant. Because it's common sense.
Ethics are ethics.
Yeah.
You spend government money to do government work, period.
Yeah.
And if there's anything personal involved in it, you don't get to spend the money on it.
Yeah, and so, so, I mean, to me, that's irrelevant. I mean, basically, he has training, and he can't say plead incompetence. I don't think he's incompetent. I think he's intelligent. I think he knows exactly what he's doing. And the thing is like, you know, ethics is super important. I took the time out of my day to be here. Where is he?
Well, he's got his attorney representing him.
Yeah, but he can still be here.
He doesn't want to put himself.
Exactly.
He doesn't want to put himself for public scrutiny.
But it implies that he doesn't treat ethics very seriously too.
I should ask his attorney.
I mean, yeah.
Let's go ask his attorney that.
That's what?
Let's go ask his attorney that.
About what?
Why he didn't show up.
Oh. Yeah, I mean, I probably, I don't know, family members, I have no idea. I mean, that's the only reason I can see
I just like to put shit
justification.
on camera and get the reason.
Yeah. But that's the only real justification I could see in the
And then when it's over, you're like PTSD. and it's like, what are we doing now? All right.
Or they can open it back up. There we go. Let's go find out what happens to Devon Reese.
So we're in that PTSD phase. Yeah.
It is time for you to go.
It is.
Recording in progress.
We'll go back on the public record, executive assistant. Director
We will be
has
on the public record.
the, Zoom channel, then open back up to public. All the public members back and have access.
Yes.
Thank you, we've had an opportunity to, discuss with our council. Any members of the commission like to make a motion on this matter? Vice Chair Walton.
I move that the commission find that Reese has failed to comply with the deferral agreement. I further move that the deferral agreement be vacated and that the commission conduct further proceedings in this matter.
I'll second that motion.
Any, just in terms of deliberation on the motion, I just want to put on the public record that, the commission, discussion found that, yes, there had been a violation of the deferral agreement, that there has to be a consequence if deferral agreements are violated, that the appropriate consequence in this case was to vacate the deferral agreement, let Mr. Reese make his case on both alleged violations, and that the trigger in the deferral agreement is a just and sufficient cause finding by a review panel, not a full finding of violation, and that is a condition that is permitted by NRS 281A. With that, any other commissioners have any comments they'd like to make? Then we'll go ahead and call for the vote. All in favor of the motion made by Vice Chair Wallen, please
Aye.
say aye. Any opposed? It's unanimous. Again, Commissioner Lowry abstained because she served on the original review panel. But unanimous among those voting. Thank you, Mr. Shipman. That will bring us to item number 5. Public comment, discussion, possible action on the proposed language access plan pursuant to NRS 233.0081.
Hey, Mr. Shipman, can I ask you a question, man? My name is Drew, and I do a little YouTube channel.
No, I'm not really not authorized to speak.
Oh, well, you represent Devon, and
Yeah, but I don't have this.
I'm just wondering why he didn't show up today.
Because it was a procedural matter, so
Oh.
this was not the
Not important enough to him.
No, I think it's just the merits weren't being discussed today. It was really just a procedural matter. But
Okay. Well, I'm just big into government. Have you seen what's going on with the library system in Washoe County?
Yeah, generally.
You do? You're aware that they use money for private events too, kind of like Devon did? Yeah, they are. Their emails show it. It'll be fun to watch it. Okay, everybody, I appreciate you watching. Drew Rebar, Auditing Reno 911. Hit the like button, share it around, let everybody know about the corruption in the government. Thank you much.
Your constituents are older than 3 minutes. I cannot respond like that. I would be out of line if I said, respond